Welcome to Understanding Human Rights Training Program. This training was designed to provide you with important information about human rights and how everyone, including those with disabilities, must be protected from discrimination. Throughout this course, you may pause at any time to take notes or return to a previous slide for review. There is a final quiz at the end of the course. You must complete the quiz to receive your certificate of completion. Let's begin with an overview of what will be covered in this section. This training was created for organizations and employers to learn about human rights and the legislation outlined within the Ontario Human Rights Code and the changes brought about by the Accessibility for Ontarians with Disabilities Act. The information was compiled from a variety of public sources, in addition to excerpts from the legislation as referenced throughout the course. This is not provided as legal advice, but as a guide to help employers and employees adapt their internal processes and procedures to comply with the legislation outlined in the following acts and code. If there is a discrepancy between this training and the legislation, acts, and/or code, or any amendments to the legislation, acts, and/or code that arise after this training has been completed, the legislation, acts, and/or code will always prevail. Training course, we will review key components of the Ontario Human Rights Code and how these important pieces of legislation apply to the requirements outlined under the Accessibility for Ontarians with Disabilities Act, or AODA. The Human Rights Code ensures everyone's basic human rights are acknowledged and respected in their workplaces and their communities, and that they are protected from discrimination. This training was created to promote a greater understanding of human rights for everyone, including employees, employers, landlords, and service providers. The main learning objectives of this training course are to help you understand the background and basics of human rights legislation in Ontario, outline the rights and responsibilities and applicability of the Ontario Human Rights Code, help you understand the connections between human rights and accessibility requirements for people with disabilities, outline what every organization should have in place with respect to policies, procedures, and training, and provide you with resources on human rights in Ontario and the requirements found under the Accessibilities for Ontarians with Disabilities Act. Understanding human rights. Human rights are for everyone, and human rights issues touch our lives every day. We all desire to work in a healthy workplace free from harassment or discrimination. We may have family members who have come to Canada to live from countries from around the world, relatives who are getting older, one of our coworkers may have a disability, or our children's friends may have same-sex parents or possibly one parent. It's important for all of us to know about the principles and concepts found within human rights legislation in Canada and the Ontario Human Rights Code to gain a better understanding of our rights and responsibilities under the Code, how to recognize different types of discrimination, and know what to do when elements of the Code have been disrespected. Ontario was the first province in Canada to introduce legislation protecting people against many forms of discrimination. The Ontario Human Rights Code comes from various international, national, and provincial laws that were developed after World War II, as well as a number of other acts that provide the foundations of the Code. These acts include the Racial Discrimination Act, 1944, the Fair Employment Practices Act, 1951, and the Fair Accommodation Practices Act, 1954. In 1962, these acts were merged to create the Ontario Human Rights Code and are commonly referred to as the Foundations of the Code. The Code also incorporates the Canadian Charter of Rights and Freedoms, which guarantees the people of Canada certain political and civil rights. International law states that we all have human rights, and the preamble to the Ontario Human Rights Code reflects this by making direct reference to the United Nations Universal Declaration of Human Rights, which was established in 1948. The Code protects people in Ontario against discrimination in employment, accommodation, goods, services and facilities, and membership in vocational associations and trade unions. Specifically, there are 15 grounds of discrimination under the Ontario Human Rights Code, which will be explained in more detail within the next section on understanding discrimination. The Preamble. The Preamble of the Ontario Human Rights Code introduces the important aspects of the Code and makes reference to the United Nations Declaration of Human Rights. The Preamble reinforces the idea that everyone in Ontario has the right to conduct their lives, their work, and their recreation time with respect and dignity. The preamble says that everyone in Ontario should have equal access to opportunities without discrimination and aims to promote respect and dignity for everyone, mutual understanding and a climate of respect, the ability to fully participate in the community, and equal rights and opportunities for each person in society. The Human Rights Code is based on 4 key concepts. These include primacy, remedial, effect not intent, and provincial scope. First, the Code has primacy. This means the Code comes first and takes importance over most other laws. If there is a conflict between the Code and a provincial or federal law, then the Code must be followed first. Some exceptions to this rule may apply. Second, the Code is remedial. This means that the Code is not meant to punish any person or group. The Code is meant to improve or remedy a negative situation and aims to eliminate discrimination through education and awareness. Third, the Code represents effect, not intent. Under the Code, even if you don't intend to discriminate, the Code looks at the effects or consequences of behaviors or actions and/or what was said. Fourth, the Code has provincial scope in that it covers work, housing, and services that are registered under provincial laws. For federal workplaces and services such as banks, the Postal Service, airlines, and the federal government, then the Canadian Human Rights Act will apply in these cases. The Human Rights Commission was established in 1961 to administer and enforce the policies found within the Ontario Human Rights Code. The Commission is an arm's-length agency of government accountable to the people of Ontario through the legislature. The Ontario Human Rights Commission also advocates for systemic change by taking a close look at the roots of discrimination through policies, programs, research, and human rights inquiries. In some situations, the Commission works with cases brought before the Ontario Human Rights Tribunal. The Code outlines how the Code protects individuals from discrimination. Part 2 of the Code explains how the Code is interpreted and applied with reference to things such as harassment. Harassment can be based on any prohibited ground and any social area outlined in the Code. We will review harassment in more depth later in this training program. Duty to accommodate. The duty to accommodate means making special arrangements made for people who need them so they can live their lives with the same opportunities as everyone else. The duty to accommodate encompasses respect and dignity, looking at individual needs, facilitating integration and participation, and ensuring barrier-free design. Special programs. Special programs can be developed by any organization to assist disadvantaged groups who have historically been discriminated against or who have been marginalized. The Code and the Canadian Charter of Rights and Freedoms both recognize the importance of these programs. An example of a special program might be a government-funded program to assist seniors with finding jobs, where they may have encountered employment discrimination because of their age. Special interest organizations. The Code allows specific types of organizations to limit their services based on specific grounds outlined in the Code. Special interest organizations include philanthropic or charitable groups, educational organizations such as religious colleges, fraternal organizations such as mutual aid societies, or social institutions like cultural community centers. An example of a special interest organization might include a charitable group that serves only people with disabilities, where they can limit their membership to include only those in that protected group. And special employment. Under the Code, special employment programs can hire individuals who have the same culture, religion, or background as the people they provide services for. Special employment programs could include religious schools or colleges, community benefit groups such as mutual aid societies, and social or cultural clubs that serve a particular ethnic group. This ends our section on Understanding Human Rights. We hope you are enjoying this training program so far. We have developed a few short questions for you to answer as a review of the information we have covered. Question 1. What federal act was passed in 1970? The Ontario Human Rights Code protects people from discrimination in key areas such as employment, accommodation, goods. Question 3. The Ontario Human Rights Code comes first and takes importance over most other laws. If there is a conflict between the Code and a provincial or federal law, the Code must be followed first. This is known as what? A. Primacy. B. Provincial scope. C. Effect not intent. D. A landlord has decided to install automatic doors with buttons and ramps in all of his rental units. This is an discrimination and human rights. Discrimination can come in different forms. The essence of discrimination rests in the principle that someone is being treated differently because of their race, disability, sex, or other personal characteristics. These areas are often referred to as protected grounds. Discrimination can involve one person or a group of people. It can be direct, indirect, or found through an entire system. It can also take the form of reprisal, a poisoned environment, harassment, racial profiling, or a denial of services. In the next few slides, we will discuss the grounds of discrimination, the key social areas affected by the Code, and specific forms of discrimination. Part 1 of the Ontario Human Rights Code lists the grounds of discrimination. In total, there are 15 protected grounds. All of these areas are considered to be a protected ground. You cannot discriminate against another person or group of people because of their 1. Race. This includes ethnic origin, color, and place of origin. 2. Ancestry. 3. Place of origin. 4. Color. 5. Ethnic origin. 6. Citizenship. 7. Creed, which includes your religion and beliefs. 8. Sex, which includes pregnancy and gender. 9. Sexual orientation, including persons who are gay, lesbian, bisexual, or heterosexual. 10. Gender identity. 11. Gender expression. 12. Age. 13. Marital status, including being single, married, widowed, cohabitation, and same-sex marriages. 14. Family status, or 15. Disability, including temporary and permanent disabilities, being in receipt of workers' safety and insurance benefits in the past or at present, learning disabilities, visible, invisible, and perceived disabilities. In addition to these 15 protected grounds, the Code also states that in certain cases you cannot discriminate against an individual based on their receipt of social assistance, which applies only to housing accommodation and includes, for example, being in receipt of government-funded subsidies and supportive housing, and record of offenses, which includes provincial offenses such as under the Highway Traffic Act, and federal offenses for which a pardon has been granted. This applies in employment situations only. The Code ensures that Ontarians find freedom from discrimination in 5 key areas, referred to as social areas. These social areas include 1. Services, goods, and facilities. 2. Accommodation, housing. 3. Contracts. 4. Employment. And 5. Vocational associations. Services can include the following: stores, restaurants and bars, hospitals and healthcare services, schools, universities and colleges, public places and their facilities such as community centers, public washrooms, libraries, malls, and parks, municipal and provincial government services and programs such as social assistance and benefits and public transit, services provided by insurance companies, and classified advertisements in newspapers and other media. You have the right to expect services, receive goods, and use facilities without discrimination. Accommodation can include situations where housing is purchased, sold, rented, or in cases of eviction. Under the Code, you have the right to fair and equal treatment when buying, selling, renting a property, or if you are evicted from your residence. This could be a house, apartment, condominium, commercial office, or hotel. Contracts are legal agreements which can be verbal or written. Under the Code, you have the right to expect fair and equal treatment when you enter into a contract and within the contractual terms themselves. Employment can include anything from being hired to being terminated from a job. It can also include other employment situations, such as being promoted, receiving overtime, vacation time, benefits, performance appraisals, and training. The Code can apply to work completed off-site, off-hours, and in telecommuting situations. And finally, every person has a right to be treated equally in a vocational association, such as a union or professional group. The Human Rights Code outlines basic forms of discrimination. These forms of discrimination under the Code include direct, indirect constructive, systemic, reprisal, poisoned environment, harassment including sexual harassment, racial profiling. We will cover these forms of discrimination in detail over the next few slides. The first type of discrimination is direct discrimination. Direct discrimination is where someone discriminates directly against another person or a group of people because they think they are different from them. For example, denying someone a job because they have a disability. Direct discrimination includes both practices and behaviors that have a negative effect on someone who belongs to one of the protected grounds. Even if you didn't intend to treat them differently, your actions, words, or behaviors in this case are discriminatory. The next form of discrimination is indirect discrimination and can also be called constructive discrimination. Indirect discrimination may seem fair and balanced at face value and can even be based on certain rules and policies, but in reality, these practices are discriminatory because they cause people to be treated differently from others. An example of indirect discrimination might include asking someone to remove their religious headscarf before entering a workplace for security reasons. Another example could entail creating a workplace policy that prohibits employees from bringing in their pets to work while not realizing this excludes those who require guide dogs to help them with orientation and mobility in the community. Discrimination is when the effects of an organization or culture's rules cause people to be treated differently. It can be a part of a system's practices, or it can be how decisions and policies are created. One example of this might be if all of the senior executives in a company play golf and will only promote someone if they play golf with them. If we think about who gets invited to play golf, then this is a form of discrimination that excludes others on a systemic level. Reprisal is when someone is punished because they have made a human rights complaint or if they have said something about witnessing discrimination, that is to say, witnessing discrimination against ground protected under the Code. Individuals cannot be punished or threatened with punishment if they make a complaint, filing a human rights application, filing a human rights grievance, or acting as a witness at a human rights hearing. This is referred to as reprisal. When words or actions make you feel unwelcome or uncomfortable in your workplace, this is known as a poisoned work environment. These types of comments or actions are reflective of those protected grounds listed in the Code. A poisoned work environment is a hostile and offensive environment for individuals or groups and negatively affects productivity and the way people communicate with one another. Examples of hostile or offensive behaviors in the workplace might include yelling, pounding fists in frustration, or slamming doors. The behaviors could be directed at one person, towards a group of workers, or no one in particular. Under the Code, harassment, including sexual harassment, is defined as engaging in a course of vexatious comment or conduct that is known or ought to be known to be unwelcome. A vexatious comment or action is something that causes someone distress and feelings of disorder. It is usually used within the context of harassment and is defined as a comment or action that is unwelcome and has little or no useful, legitimate purpose in the context in which it takes place. Harassment includes comments or actions that are unwelcome and are usually repeated more than once. Examples of sexual harassment are asking for sex in exchange for a favor, making unwanted physical advances or touching, and making sexually oriented comments about a person's physical characteristics, among many others. Harassment can be based on any of the protected grounds or social areas listed under the Code. It's not always the intent of the harassment that matters. It's usually the effect or impact of the harassment that is of concern. Employers and services providers hold responsibility for preventing harassment, and everyone in workplaces and other environments should be aware of what to do to prevent and put an end to harassment. This ends our section on discrimination and human rights. Please answer the following questions in order to summarize your understanding of this section. Question 1. When planning a corporate fundraising event, an employer suggested that a pregnant employee not participate because they felt the event would be too physically demanding for her. This is an example of what type of discrimination under the Code. The Ontario Human Rights Code aims to protect Ontarians from discrimination in 5 key social areas, including services, accommodation, contracts, employment, and vocational associations. Which of the following would be an example of a service? A. Trade union. B. Apartment building. C. Library. Joe has applied for a job in sales at a local company and he uses a wheelchair. After his interview, he is told that the company is unable to hire him because they cannot accommodate disability and human rights. Human rights in Canada and in Ontario are inextricably linked to making society accessible to people with disabilities. People with disabilities are considered a protected group under the Code and cannot be discriminated against with respect to housing, fair employment practices, and other aspects of daily life in their communities. The Code provides freedom from discrimination and equal rights and recognizes that every individual deserves dignity and respect. The Code realizes that people with disabilities are entitled to these same rights. According to recent estimates, approximately 1.8 million Ontarians, 15.5%, live with a disability. The number of Ontarians with a disability is increasing as the population gets older. By 2026, it is estimated that approximately 20% of people in Canada will have a disability. These statistics highlight the importance of being mindful of individuals with disabilities and the special requirements they may have in their communities, where they learn and where they work. In 2005, the Ontario government enacted the Accessibility for Ontarians with Disabilities Act, AODA. The Integrated Accessibility Standards, Ontario Regulation 191/11, or IASR for short, were established under the AODA. The standards cover the areas of transportation, information and communication, employment, the design of public spaces, and customer service. Many requirements outlined in the IASR are currently in force, with the remainder to be phased in over time. The goal is a fully accessible Ontario by 2025. Ontarians with Disabilities Act, AODA, a disability includes physical disabilities, for example caused by injury, birth defect or illness, mental or developmental disabilities, learning disabilities, or mental disorders. The AODA uses the same definition of disability as the Ontario Human Rights Code, which includes both visible and non-visible disabilities. AODA definition of disability. According to the Accessibility for Ontarians with Disabilities Act 2005, Section 2, a disability is defined as a. Any degree of physical disability, infirmity, malformation or disfigurement that is caused by bodily injury, birth defect or illness, and without limiting the generality of the foregoing, includes diabetes mellitus, epilepsy, a brain injury, any degree of paralysis, amputation, lack of physical coordination, blindness or visual impediment, deafness or hearing impediment, muteness or speech impediment, or physical reliance on a guide dog or other animal or on a wheelchair or other remedial appliance or device. B. A condition of mental impairment or a developmental disability. C. A learning disability or a dysfunction in one or more of the processes involved in understanding or using symbols or spoken language. D. A mental disorder, or E. An injury or disability for which benefits were claimed or received under the insurance plan established under the Workplace Safety and Insurance Act, 1997. Persons with disabilities frequently encounter barriers in their everyday lives. Barriers can be physical, attitudinal, or found throughout an entire system. Employers, landlords, union representatives, and service providers must ensure that these barriers are reviewed and addressed within their facilities, services, and procedures. Under the IASR, the customer service standards require that all organizations operating in Ontario work to ensure that their businesses or services are open to all customers and respect the dignity, independence, and value of persons with disabilities. Making places barrier-free for individuals with disabilities benefits both businesses and their customers. The other standards in the IASR obligate organizations to provide other accessible types of communications and information to individuals with disabilities, develop accessible employment policies and procedures, and ensure various forms of transportation are accessible. Dependent on the size of the organization, additional requirements for the provision of accessible formats, establishment of accessibility policies and procedures, and provision of training within their workplaces may apply. As we mentioned earlier in our training, the Code protects individuals from discrimination in a number of areas. Employers, service providers, unions, and landlords all share a duty to ensure special arrangements are made for people who need them. Even if your facilities and services are designed with 100% inclusivity, you may still find that you need to accommodate someone with a disability. The duty to accommodate is a shared responsibility, and all the involved parties must work together to ensure accommodation solutions are successfully created. Landlords, for example, could provide automatic entry doors and accessible washrooms within their properties. In addition to the Human Rights Code, other laws related to accessibility may apply to organizations covered under the Customer Service Standard, such as the Ontario Building Code. It's always good to keep in mind that AODA requirements do not replace or change what is required under the Code and any other laws. For example, in addition to complying with AODA, a service provider must still comply with the Ontario Human Rights Code, which prohibits discrimination on the basis of disability in goods, services, or facilities, accommodations, contracts, employment, and vocational organizations. The AODA standards have not changed the rules that exist under the Ontario Human Rights Code. In situations where the accessibility standard establishes different rules than other laws, a provider must comply with both. For example, under AODA rules, an organization must provide a way of receiving feedback on the services the organization provides to people with disabilities. In this case, the provider must comply with the rules of the Code in addition to AODA rules. To the requirements outlined in the Integrated Accessibility Standards Regulations, all obligated organizations, public or private, large or small, must provide accessibility training for their employees and volunteers, as well as training on the requirements set out in the Ontario Human Rights Code. Training helps to prevent and address human rights violations and disability discrimination through awareness and education. This ends our section on disability and human rights. Please review the following best practices situations and answer the summary questions to refresh your understanding of this section. Question 1. Individuals with disabilities are considered a protected group under the Human Rights Code, both Canada and Ontario, and cannot be discriminated. Question 2. What standard under the Accessibility for Ontarians with... Question 3. A union representative. Conclusion. Respect, dignity, and freedom from discrimination form the cornerstones of human rights in Ontario. These are the foundational values that flow throughout our society and our public policies. They are also the legal rights we have to support us in our workplaces, where we live, where we play, and in our daily interactions in the community. The Human Rights Code is law, and all employers, landlords, and service providers must practice and follow the information outlined in the Code in order to ensure that housing, workplaces, services, and other aspects of daily life are free from discrimination and harassment. Human rights complaints can be costly to employers, landlords, and other service providers through compensation claims and other grievances. When we all make a commitment to understand the value of human rights in preventing discrimination, everyone in society wins. Trust you have enjoyed learning more about human rights and have gained a greater understanding of discriminatory practices and situations. Being aware of our human rights is a daily activity and plays an important part in where we live, where we work, in our communities, and where we do business. Human rights in Canada are rights that are universally acknowledged and are also directly connected to removing barriers and accommodating people with disabilities. Please test your knowledge of what you have learned in this training program by answering the questions on the final quiz. Thank you for participating in this training.